Good morning, everyone. I'd like to call to order the City of West Palm Beach Code Enforcement Special Magistrate hearing for February 2nd, 2022. My name is Keith Davis. I am the Special Magistrate appointed by the city to preside over today's agenda. Before we begin, if you could silence your cell phones so they don't interrupt the proceedings, that will be appreciated. If you're going to be speaking to me about any of the matters on our agenda today, your testimony needs to be sworn, so I need to place you under oath. I can swear everyone in at the same time. If you'll all please stand if you're able and raise your right hands, I will swear you in. Thank you. Do each of you swear or affirm under penalties of perjury that your testimony today will be the truth, the whole truth, and nothing but the truth? Thank you. You can all have a seat. We'll start. We have a few cases with city staff that have to be called. We'll take those, as well as respondents who are present who signed in. Take those cases first. When your case is called, if you're a respondent, please come up to the podium to my right. The way we'll proceed with each case is I'll hear from the city first. The city will present testimony. There will likely be photographs and or other documents which will be shown on the screens. You'll have an opportunity to see those. Once the city has concluded its presentation and made any recommendations for the disposition of the matter, you'll then have an opportunity to ask questions of the city's witnesses, present your own testimony. If you have additional documents or photographs that you want me to consider, that will be the time to produce those. Once I've heard everything and reviewed everything from both the city and the respondent, in all likelihood today I will enter an order that resolves the matter in some form or fashion. So with that explanation, let's go ahead and call the first case.
Agenda item number 4, case number CE 2106-0301, case address 4685 North Haverhill Road.
Good morning.
Good morning.
Attilio Bilal, Inspector for the City of West Palm Beach. Property was initially cited on 6/18 of 21 for demolition without a permit. We received
Doing demolition without a permit? Is it?
Yes.
Okay, thanks.
We received the notice of violation was mailed in regular mail and certified mail. The certified mail was signed for, but the certified mail was returned unclaimed, undeliverable. It was also posted on City Hall. No permits have been obtained for the electrical and the plumbing. However, a permit number 22010983 for the interior demolition has been applied for on 1/25 of 22, but not issued. I've spoken with the property owner several times and advised them what to do in order to comply. City recommends 30 days to obtain the permits necessary and $200 a day after that.
Was the property posted?
Yes.
Thank you.
I wasn't clear, was the certified mail returned or did they sign for it?
It says certified mail was signed for, but also the certified mail was returned unclaimed, undeliverable, left with an individual on October 21st of 21.
All right, but you did post City Hall and the
Yes.
property as well?
Yes, we received proper posting.
All right, well, if it was signed for, then you have proper notice with the certified mail. If it was returned, then you have proper notice with the posting that followed the return. So either way,
We had to reschedule this case.
okay. Is anybody here on behalf of the respondent, by the way? It does not appear that they are, but you do have proper notice regardless. I have reviewed the photographs while you were testifying as well. Is there anything else?
That's it.
Okay, then I do, based on the evidence and the testimony, find the property remains in violation as cited. In this case, I will accept the city's recommendation, allow the respondent 30 additional days to obtain the necessary permits for the work that is being done. After that, daily fines of $200 per day will be assessed until compliance is achieved.
Thank you.
Agenda item number 5, case number CE 2110-0426, case address 1200 South Flagler Drive, Unit 202.
Good morning. Attilio Belisle, Inspector for the City of West Palm Beach. Property was initially cited on 10/28 of 21. We received proper posting at City Hall. And let me see here. I don't see, it was posted on site too as well, but I do not see that it was signed for or certified mail. Yes, certified mail was sent. Property was cited for renovation of the unit of the interior without proper permit for the plumbing or the building. They do have a building permit back in 2018. It was applied for but not issued, permit number 18050518. However, it was never issued. I spoke with the owner of the property and advised him what needs to happen in order to comply this case. And he instructed me that he was going to do whatever it takes to comply. However, I have not seen any permits applied for since the conversation I had last month.
Now, the 2018 permit that was applied for wouldn't capture this either way, would it?
No, it wouldn't. It was applied for but never issued. The gentleman told me that he did the renovations himself. He said that he was aware of what he was doing, but he didn't think that it was required to have a permit. If you see right there in that photo, it's a fire issue, a separation between the unit below, which is actually like a card room for the building. And there's no fire separation. They just busted a hole in the floor in between the two floors.
Okay. What is your recommendation for release? Of this?
30 days and $50 a day.
30 days and what?
$50 a day.
Is there anybody here on behalf of the respondent for this case? All right, well, with the posting and the certified mail, the city does have proper notice, even though the respondent is not present. Based on the testimony and the evidence, I do find property remains in violation as cited. Again, I will accept the city's recommendation and allow the respondent 30 additional days to comply. After that, daily fines of $50 per day will be assessed until compliance is achieved.
Thank you.
Agenda item number 7, case number CE 2201-0269, case address 1401 Clare Avenue.
Morning.
Good morning.
Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 1401 Clare, also known as Grandview Market, was initially cited on 12/3/21, case number CE 211-20050. That case was closed as a result of the respondent requesting some additional time in order to obtain local legal counsel to be represented here at the hearing today. We re-noticed this particular case on January 22nd of 22, once again due to the request of Mickey Camillo, who's the legal counsel representing the property owner. Certified mail was sent on 1/24/22. City did receive a certified signed mail receipt. We have that on file. It is a part of the record. Additionally, confirmation of the notice of hearing via email was received on 2/1/22 from Mickey Camillo, legal counsel for the respondent / owner located in Charlotte, North Carolina. The copy of the notice of violation, notice of hearing, was posted at the property on 1/22/22. Additionally, a copy of the notice of violation was left on the desk of Mr. Joe Muniz at 1401 Clare, who is the general manager on site. Let's see. Property was cited for the following code sections: 26-35-B, which specifically deals with the imposition of the fine amounts. Property was also cited for 34-35-2, which specifically dealt with the loud music, which was observed by West Palm PD, which actually precipitated the police department being called out. And once the police were on site, they noted that there was a large gathering. It was described, I guess, 150 to a couple hundred people were at the location. They were also cited for 78-152, which deals with obtaining a special events permit for events such as the one that was hosted there on site. More specifically, Special Magistrate, with regard to 26-35B, the city deems that particular code section irreparable in nature, as the event was held without any approvals from the city on 11/28/21, which was once again the night of the event, and actually a shooting took place at the event. Code section 34-35-2, once again, loud music was reported to West Palm Beach Police Dispatch, again, which precipitated the police going out. Also, I had Sergeant Gellin pull some of the more recent noise complaints for that location. On 11/28/21, the night of the shooting, there was a call. On 11/12/21, there was another call to West Palm Beach Dispatch for loud music. And again, more recently, 10/31/21, there was another call to Police Dispatch for loud music. Let's see, 78-152. Pretty much what happened, Special Magistrate, not only did they sanction but held a special event, again, which was not approved by the city of West Palm Beach. The event resulted in gunshots being fired and an individual being shot and hospitalized as a result of it. And so what the city is requesting as a result of this, the city's requesting, one second here. The city's requesting a one-time fine of $15,000 and a finding of fact. Once again, obviously, the respondent hosted an unapproved event, which resulted in a shooting at the location. Fortunately, there were not other individuals, well, more individuals that were shot and or killed as a result of this sanctioned event held at the location. And per 26-35B, Special Magistrate, I believe you have the latitude to fine up to $15,000 per violation if a violation is found irreparable or irreversible in nature. And obviously, it's already transpired, and so there's absolutely no way that it could be corrected. This was a very dangerous event, obviously, with the shooting. And again, we're very fortunate that more individuals were not shot and or killed. And so in light of that, the city is requesting the one-time fine of $15,000 and a finding of fact.
What is the connection between your testimony about what occurred and there are two photographs with a a poster, I want to.
Right. Those were the posters that were at the location, advertising the event. And
You stop the slideshow and just leave it on
yeah,
a couple of
that
questions.
was
November 27th, the date that this occurred.
the event was hosted on 11/28/21.
Mike, did that event start on Saturday night and culminate overnight?
It started on.
Well, the poster advertises 10 p.m. to 4 a.m., so that would be November 27th into the morning of November
Right.
28th.
Date time reported per the police report 11/28, 2021 at 1:50 in the morning.
So that would be in between the 10 p.m. and the 4 a.m. Do you have an officer present to testify about what they observed?
Sergeant Gillum is actually here. And so he is privy to some of the events that took place as he was there toward the.
Sergeant, were you
end
here
of
when
the
I
event.
swore in the folks to testify? Thank you, sir. Go ahead and state your name and position with the city, then you can tell me what you witnessed.
Brian Gellin, Sergeant. I'm with Code Enforcement. That night, I was working actually as patrol sergeant, so I wasn't with Code, so I was working overtime. I was in the north end of the city when apparently this call came out. I was notified by the south end sergeant of the large party. As Code Officer Williams had mentioned, it was an unsanctioned event. Apparently about 10 or 15 police officers had to respond to the to Grandview Heights, the warehouse area, to basically deal with the amount of vehicles being driven throughout the area, the amount of people that were at the event, along with being at the scene. I didn't respond until after the fact. When I did get there, most of the vehicles were gone. When the vehicles were there, though, as Mike was saying, there were shots fired, which basically cleared out the whole location. Once I responded, there was alcohol everywhere being sold. There was bottles, beer, you name it, throughout. There was a DJ booth set up on the outside section. But again, when I got there, basically the scene had cleared out.
So you did not personally witness the excessive noise allegation?
No, not myself personally, other than from another sergeant that was on scene.
Okay. All right, don't go too far. Once I finish with you and Mr. Williams, respondent may have questions for both of you, and I'll give you the opportunity for that in just a minute. Mr. Williams, is there anything else on behalf of the city at this time?
No, actually, there were members of the community that had indicated that they were going to be here to provide some additional testimony with regard to the noise on previous occasions. I did give them the date and the time, but doesn't seem to be anyone here today. But in light of that, I mean, that's all that I have at this moment.
Other than your testimony, is there any other evidence regarding the excessive noise allegation?
No, beyond the fact, as I said, I had Sergeant Gillum pull up from PD some of the more recent noise complaints that came into West Palm Beach Dispatch.
Those were on different occasions than this?
Right, they were on different occasions. That on that particular night, West Palm Beach Dispatch was called, and that's what precipitated the police coming out to the location, was the loud noise. And when they arrived on scene, it actually says here in the police report, it says, on the above date and time and locations, officers were present at Grandview Marketplace for a noise complaint. Approximately 3 gunshots were heard and multiple vehicles fled the area. Later, a victim was located at St. Mary's Hospital with multiple gunshot wounds.
Okay. All right, thank you, Mr. Williams. Anything else from the city before I hear from the respondent?
Not at the moment.
All right, thank you very much. Good morning, sir. If you could put your appearance on the record, and then you can have either talk to me about the case or have you can have testimony from your client or ask questions of the city's witnesses, however you want to proceed.
So far, Mr. Special Magistrate, I have no questions other than the ones you asked, which I thought were pointed and appropriate. My name is Michael Keene. I'm with Lauren and Keene Law. I represent the property owner, AP Warehouse District, LLC. I had been advised by the tenant and a representative of the tenant that there was going to be somebody from the tenant here to speak to you today that had been dealing with counsel. Assuming that nobody is here since nobody has stepped up, that would be one more promise and representation that the tenant has made to us that has turned out to be untrue. We appreciate the commission's rolling this to another docket so that I could be present once we learned about it, which was a month and a half after the event occurred. The tenant here, Grandview Public Market, and it's a NHB, Grandview Public Market LLC, who has been placed on notice twice of me now of this hearing, demand that they come here and explain what happened, because we're obviously of limited ability to do that. With me is Tricia Schmidt. She is the landlord's property manager, a third-party property manager, but we have nothing to do with running or operating the premises other than we lease it to a tenant who is required to follow, obviously, all rules. That being said, let me dive in on something I wasn't there for, Mr. Williams wasn't there for, the sergeant was there for after the fact. There's an indication, and there's been discussion about gunshots fired. What I have been told, and I can only tell you what I have been told, because again, I do not know, and frankly, couldn't find a news report about this shooting either, because I looked. But what I was told is that actually there was an event there like there is every night. It is a place of public accommodation. It is a place that has a number of food halls and bars and restaurants. That's the nature of the tenant and what they operate. I suspect that if one wanted to make an argument, one could make an argument that they hold special events every night of the week, or that every happy hour or party that every bar holds is a special event. I don't believe that that is what constitutes a special event under the city's code. That being said, I also understand that the shooting that occurred, and again, this is hearsay, Mr. Magistrate, it's what I've been told.
Sure.
That the shooting occurred, and it seems that Mr. Williams' reading from the police report indicates the shooting didn't occur on premises. It didn't occur in our premises. It didn't occur in the parking lot of our premises. Shots were heard fired, and somebody was found at St. Mary's. The shooting, as I understand it, occurred blocks away from the event, whatever that event happened to be. And as it relates to the noise violation, we have, no direct indication of anybody that was there and witnessed it. I'm not suggesting that if there was a party that there was not perhaps noise, whether it constituted a violation or somebody simply called to complain, I don't know. And the history of a couple of other noise violations at a facility like this in a several-month period, also with no apparent findings or notices even, isn't particularly surprising. I don't think that this merits a $15,000 fine of the landlord, who was completely and utterly unaware of this event. We have notified the tenant of this default. We have placed them on notice that if they don't defend and indemnify and take care of this matter, we're going to seek to evict them, and we will. Again, I was told, today is Wednesday, I was told Monday afternoon that there would be somebody from the tenant here, that somebody from the tenant had been working with the city. I don't know if any of that is true, Mr. Magistrate, I don't. But that's what I was told, and we certainly came to at least represent the landlord's position. As it relates to the concept of special event, and the code says what it says, and it's section 78-151, it seems to indicate that when, and it's a broad definition of show, festival, rally, celebration, but typically involves the acquisition of permits to hold these things on public properties or in public rights of way. And while it says that it can apply to private property, It says, if held wholly upon private property, that which will nevertheless affect or impact the ordinary and normal use by the general public or public property or public rights of way within the vicinity of the event. So the special event permit section really seems not to apply to the Wednesday night happy hour or the Thanksgiving party that takes place at a place that holds these types of events, again, probably weekly, if not more often than that, but something that's truly going to have a regional impact on the public. It's going to impact traffic flow. It's going to impact the public's ability to use other public rights of way within the vicinity. I don't really think the special event permit applies on this. I am as aggravated with the tenant and incensed with the tenant and their failure to make sure that that was the case in advance as much as this commission is. And the landlord is prepared to move against the tenant if and when we need, but I feel that the threat of the fine against the landlord is really unmerited. The landlord had nothing to do with this.
All right, thank you, counsel. I have a question probably for the city attorney, but could you give me the city's position on, and I had already pulled up the definition of special event and how this does qualify as a special event compared to what they do in the normal course.
Special Magistrate, it's my understanding, and I'll ask Sergeant Gellin and Mr. Williams as well, but it's my understanding that this particular establishment, while it does have some, because it offers food and some background music or some type of, maybe a performer like inside or under the purview of the actual establishment on a regular basis, because that's what they do. This was a event that was, if I understand correctly, this was an event that was not on their regular schedule that they kind of publish on their social media or on their website. In addition, there may have been another one that we know about, the city knows about, where they're doing things off the books, so to speak. These are not regularly scheduled things. And the point of the special event permit, there is a public aspect, but as council indicated, there's a private aspect when it tends to burden the services that the city provides. In other words, if the traffic kind of spills out over the property line, and if people coming in, there's such a big crowd, because when you get a special event permit, which all you have to do is make a phone call to the city, and the city will tell you if you need one. It's in the interest of the city to watch out for the health, safety, and welfare of everybody, and that's part of the purview of such a special event permit. So that is the very essence of preventing, controlling, organizing an event like this, is to have the special event permit, which can control noise, control traffic. You would have perhaps, there's various departments in the city that would review what is proposed to go on from a fire aspect, building, zoning, traffic, things of that nature. And had they done that, had they gotten it, because they truly came under the purview of needing one for an event like this, because it would burden all these extra city areas and services, then something like what happened could have been prevented, because the city could have said you need to have security, or you need to have off-duty police officers, or you need to have certain other control mechanisms to keep a crowd under control, to keep traffic organized. And that's why the city believes that the special event permit comes into play. One of that aspect is also to control noise. And again, Mr. Williams may be able to speak a little bit more to the fact that, again, this was an event that was not part of their normal everyday events that were already under the purview of their existing BTR. It was totally something that was transformed and wasn't covered by what they were already permitted to do. And that there is a potential if I recall correctly, another event that again was off the books.
Okay.
Actually, just really quick, they also outsourced it to an outside vendor. It wasn't part of their venue. Again, as Arlene had mentioned, they have a website, they list all their events and what's going on, who's playing. That night, they leased it out, basically subleased it to another promoter, club promoter, who then put on his own show. So he probably paid whoever the amount of money so he can have his show there, which led to all this other stuff. So when I got there as well, there was armed security that they had hired, not Grandview Heights, but the promoter. They're all decked out in TAC gear, SWAT gear, drop-down holsters. That's not your average security officer to deal with an event.
Well, and actually, I had a question for you along those lines, Sergeant. Did the, council sort of argued that, this venue, or this business, I don't want to say conducts events, but runs their business every week, and there's activity going on. Can you explain to me the law enforcement response to this November 27th, 28th event compared to the normal course of things at
Leading
this
up to
venue?
this, apparently because of those previous weeks, they were having those other events that were unsanctioned. Again, they were probably hiring outside promoters to do this. That was not on the website, bringing outside entities to come in, which generates the calls for service for the loud music and so on. So this obviously led up to this weekend where it just kind of escalated. They allowed it to continue, and that obviously led to the shootings. So many people being there, the lack of police officers being there, the lack of any medical, the fire side, or any other means of egress.
You testified that you were not present at the time the shooting occurred. Were you involved with either speaking to or seeing the gunshot victim or victims?
I never saw any of the gunshot victim. They were already transported before I even got there. When I got there, again, most of the parking lot was cleared out. I saw the after effects of all the alcohol, throughout the parking lots, inside the facility. Met with some of the security officers there to ask, hey, who's involved or who's running this? In the police report, I would just have to refer back to this on the promoter, the show promoter, and who then led us to the general manager who was not on scene, which then Mike and I went that following Monday to follow up with.
Okay, thank you. And then I have one last question for Mr. Williams, and I'll come back. Do you have any testimony regarding, as city attorney suggested, the relationship between the business tax that was paid for and the activities that covers compared to the alleged events that we're talking about?
Well, this event was clearly above and beyond what a typical BTR or what their specific BTR would authorize. They have, it's probably entertainment and food, okay, which an event that was held as, such as this is well beyond their business tax receipt. In fact, they would have needed the special events permit once again for the prior inspections held by maybe an electrical inspector or police going out or fire going out, looking at egress issues, and also ascertaining how many individuals are going to be there. So as a result of those facts, then they would be advised that, yes, you can do this, no, you can't do that. Also, there was a DJ, okay, so that also came into play, and the BTR that they were issued does not allow for them to have DJs blasting music throughout, the community.
So the special event permit would cover any DJ use?
Right, exactly, if it would be approved.
Okay, all right, thank you. Counsel, do you have questions based on the testimony I just elicited or any
I don't.
additional?
I think you've again asked all the questions, Mr. Magistrate.
Sorry for doing
I would, no, I appreciate it. Listen, we're all, You have a police report, I don't even have that. They're reading from a police report, I don't even have that. Again, there's a lot of reference to they. We're not the they. We don't have a business tax receipt here, the tenant does. The tenant purportedly hired an outside promoter to promote whatever was going on in this premises that night. Something spilled over, and I think the city attorney's discussion was interesting, followed up by the officers' discussion of, well, you know, if they, again, I'm going to use the they too, because the they ain't me. If they had called, they could have known what security to have. We now know they had significant security on site. We could have evaluated what was going to happen. Well, it certainly seems from everything I've heard, both from Mr. Williams and then more importantly from the officer who at least was there in the aftermath, that what may have, I'm going to say, turned into a special event, I don't even know that that's really accurate, something that was planned seems to have spilled over, right? Something that was planned seems to have gone beyond that. I don't know if there was an altercation inside the premises and security took care of that altercation by getting rid of the people that were causing it, who then 2 blocks away fired gunshots. Again, didn't happen inside. As I understand it, didn't happen in the parking lot. Again, I don't have the police report, but that's from everything I've heard and been told before today and heard today, is this occurred a couple blocks away, so something spilled over. This wasn't an event that was planned to spill over, or I certainly haven't heard anything that indicates that. And again, I'll simply come back to, I'm a little bit hamstrung because as the landlord, we had as much idea this was happening as you all did when it happened. And frankly, we didn't know about it until 6 weeks later because all the notices that had been delivered were delivered to the operator and the person who's on site and does this. So.
All
Special
right,
Magis-
anything else?
That's it, Mr. Magistrate.
May I make a couple of remarks in conclusion for the
Go ahead.
city? Just in response to council, the notice of violations were sent to the property owner per the tax appraiser's office. So they did receive those notices. That was up in the Carolinas. But in addition, we did do posting as required and even hand delivering to the manager on premises. I understand that manager may not be their particular person, but we did 4 different ways to get them, to put them on notice. Council makes the remark that this was an event that wasn't planned to spill over, and that's the whole point. With a special event permit, you minimize the opportunity or chance that anything will spill over. That goes to the point. The final point being, you know, we've got layers and layers and layers here. A property manager with a landlord, with a tenant, then with a manager of the tenant, then with a sub-promoter of the tenant. That's the point. The property owner is the ultimate responsible party. They've got to know what's going on with their premises. And it can't be up to the city to be a property manager of everybody's property. The city comes in with health, safety, and welfare measures. Yes, police respond when needed, et cetera, fire responds, things of that nature. But ultimately, every property owner has a duty to manage and watch their own property and know what's going on and not know 6 weeks afterwards what's going on only because somebody from the city tells them what happened. And so, again, that's the basis of the city's argument of why what occurred also required the special events permit and why that's a violation. Thank you.
All right. Any other testimony from the city?
Yeah, actually, once again, per the police report, it specifically states 3 gunshots were heard coming from the corner of Clare Avenue and Caroline Street, which is actually right directly across from this particular building.
All right, and I think there's been a lot of reliance on that document. I think it's only fair to show that to respondent's attorney, let them have it.
Sure.
I'm going to give you an opportunity to peruse that, and if that generates any additional argument or questions, I'd be happy to give you the opportunity.
Mr. Williams, would you like to submit that report for the special magistrate to review?
Yes, actually, it's a part of the case file, but yes, we can have that.
Police report, go to like the fifth one down or so. Scroll down. Down, nope. Nope, all the way down.
Yeah, there you go, Monique, right there.
Mr. Magistrate, it really doesn't raise any additional questions. It, I think, confirms that this was kind of a spillover that occurred and that gunshots were fired off premises. I'm not sure it adds anything or that it raises any questions, but I appreciate
I certainly wanted you to have the opportunity.
I thank you for that.
To take a look at that.
And I'm not suggesting, by the way, that we, obviously we're here, we have notice of this. Our general counsel in North Carolina is involved, she retained me to be here. We were aware from a porter the next day that there was a lot of trash on site. We perused social media, we found out what happened, but when we actually received the notice, and again, I appreciate the city working with us to reset this for this date. I'm not suggesting we didn't get notice or that you didn't all do it properly. I'm simply suggesting that our role here, particularly when you're talking about something that's unsanctioned from everybody's perspective, right? It's I guess, easy to say after the fact, but unless we have a 24-hour a day, 7-day a week property manager at every property that a landlord owns, monitoring the goings-on of a tenant, which frankly I think would probably violate their covenant of quiet enjoyment to an extent. And I understand the landlord, of course, is ultimately, the property owner is, of course, ultimately responsible for their property. But in this instance, I think notices and the if there is a guilty party, the tenant is also an appropriate focus.
Okay, thank you very much.
Thank you.
Any city has the burden. Is there anything final that you want to put on the record before I wrap this one up?
No.
Well, we can submit the report for your perusal if you haven't.
I've seen it. It's in the file. I've been looking at it as well. Thank you. Okay, so first of all, we do have proper notice in this case. In code enforcement matters, the notice is to the owner. I believe the city has provided proper documentation with the certified mailing. Notice also can be achieved under the statute by providing notice to the property manager if it's a business. So even if that's not the owner, that is considered technically proper notice. Respondent is also represented by counsel and present at today's hearing. So I do find proper notice. In terms of the violation, based on the testimony and the evidence that I have reviewed, I do find that there was a violation of City Code 78-152 regarding the special event permit required. I think under the definition of special event, combined with the fact that this particular event was specifically advertised, in my view, that there was a violation of that city code section. Whether there were other regular occurrences that the way that this business operates. Hopefully, there have not been multiple reported violations of that code section. But for this event, I do find that there was a violation of 78-152. For 3435-2, I mean, I really only have general hearsay testimony. I understand that that was what precipitated the police call, but I really have no evidence that anybody came here and said that they heard excessive noise. I don't think it's appropriate to rely solely on hearsay evidence to find the violation, and that's really all I have here. So I'm not going to find the violation of 3435-2. I do believe, though, that the special event permit violation of 78-152 was an irreparable and irreversible violation under 2635B. I'm not going to find that you're in violation of 2635B. That's not really a substantive code section, but it does provide the parameters within which I can enter a ruling in terms of assessing a fine and that sort of thing. So I do find 78-152 as a violation, and I find that that was an irreparable and irreversible violation. You can't undo this once it's done. I meant to ask, there was some general testimony about previous noise complaints, but has there ever been an actual code enforcement case against this property for this type of thing prior to this one?
No, and again, I did have Sergeant Yellen pull some of the more recent calls into police dispatch, and again, those dates were 11/28/21, which was the actual night of the shooting, 11/12/21, loud noise, and 10/31/21. There was again, those are some of the more recent calls into police dispatch. But I haven't written any cases per se. They have not been cited on prior occasions with regard to excessive loud music.
All right, so for my purposes, this is really the first offense
Right.
for this. And I understand, there's some serious implications, but this is the first time they've had to come here for
Right.
this. Okay. Give me just a second. All right. And I absolutely understand that the landlord was not involved with this and did not participate in this, did not sanction this, but at the end of the day, the property owner is ultimately responsible, and I guess, that is one of the risks you run if you're not on site as much as whether it's all the time or whatever you are, the property owner ultimately is responsible for their tenant and the tenant's behavior, so that's why it does fall to the landlord, and then what the landlord does with the tenant, that's between y'all. So, given those circumstances and the fact that this is the first time this property's ever been in code enforcement for any type of violation like this, at least, I am going to impose a one-time fine. I'm not going to impose $15,000, but I'm going to put this at $7,500, which is half of that. I think that that's appropriate given the circumstances at the event and given all the other circumstances that I've articulated. Does the city want to give any particular amount of time before you record that as a lien for them to pay it, or are you just going to?
No particular time. Kristen, how exactly does that work?
If there's no time given, I can we just prepare the lien, and the lien is there until the fine is paid.
Okay, so what's going to happen is
really
I'm
just
going to
your
enter an
decision.
order that memorializes what I've just said. There's a little bit of processing time, but not a lot. So once that's signed, the city's entitled to record that order as a lien against the property. So if it goes unpaid, that will remain as a lien, and when you pay it, if you can get it paid before they record the lien, you might be able to avoid it being recorded at all. I don't know how quickly or how slowly that process works. If not, if it gets recorded and then it gets paid, then a release will be recorded as well.
Can I ask the indulgence of 15 days to pay it before it's recorded so that we can get something
I mean,
processed
I have
and
no
paid
objection to
and-
that. I'd look to I can't tell the city how to tweak its process, but
I'm asking the city attorney as much as you, Mr. Magistrate.
15 days, no objection.
beg your pardon?
The 15 days that he's asking, we would have
Sounds
no
like the
objection.
city's in agreement with that, so then, sounds like 15 days that it won't get recorded before then, so.
Procedurally, Ms. County Attorney, should that be sent to your office or your attention, or?
Can I refer you to Kristen right next to you, and she'll be able to tell you?
Certainly.
Okay, all right, I appreciate everybody appearing for this and good testimony, and thank you both. Thank you all.
Thank you for your
Yeah.
time and indulgence, Mr. Magistrate.
Okay, agenda item number 10, it's a construction service case, my oversight. Case number CE 21070389, case address 720 Winter Street. I apologize for the oversight.
Good morning.
Good morning.
Joe Valdez, Building Inspector with the city.
Yes, sir.
This property was cited on 7/30/21 for,
20, excuse me, 20, 720, sorry.
for illegal, a deck that was built without permits per Florida Building Code 105.1 and without inspections 110.3.
Joe, could you speak into the microphone more?
Oh,
Thank
you
you.
can't hear me? I'm sorry. Did
I've
you hear
been-
everything?
I was able to hear, but that's
Okay,
definitely easier
I'm sorry.
now.
I apologize. So they were giving extensions after that on 8/30, 10/5, 11/1. And they have applied for permits. There are notes on the permits that they have to address, and, but they haven't been issued the permit. So the city's willing to give them 30 extra days to take care of those issues on the notes. And after that, it would be $50 a day.
Okay, so we have a permit that's been applied for. It
Yes.
has outstanding comments that need to be addressed
Yes.
before it can be issued. City's
Correct.
recommendation is 30 days to get all that
All
taken
that
care of and
taken
get the
care of,
permit
yeah.
issued. Or after that, $50 a day if compliance
Correct.
is not achieved. Okay, thank you very much. Let me come over to the respondent. Sir, if you could tell me your name and address, and then you can tell me about the case.
My name is George Scholl. I'm the owner of 720 Winter Street.
Yes, sir.
And I did get the violation, but I didn't understand the notes. They're all in building codes, and I just didn't understand them.
Are you doing this like an owner-builder kind of thing, or you have a
Yes.
contractor?
Yeah, the deck is finished. It's 3 years old.
Okay,
And my neighbor, who we will not name, turned me in for that.
understood.
So, for the deck. So I tried to fill out all the information that I could, but I guess there was something wrong with the permit, and I guess I should have called in, but I didn't, and just didn't understand him. I did get a home inspector to help me with it right before I got the violation. So I guess we'll figure out what's wrong and resubmit it.
Yeah, I think I mean, I know that comments are written pursuant to the building code, but if you have someone who understands the building code, that you should be able to get through that.
Yeah. I mean, can I talk to somebody to tell me exactly what they were so that we can straighten that out?
Well, if you can call the actual person that's doing the plan review, and they will help you with that.
Okay,
It should be on the notes, his name, and they're more than happy to help you
okay,
through the process.
all right.
All right, well, I'm happy to give the additional 30 days, but I think that will require some kind of putting this at the top of your list of things to do to get that done in time.
Yep, it is.
Okay. Is there anything else you'd like to tell me, sir?
Nope, no.
Okay. Anything else from the city?
No.
All right, well, I do find proper notice. Respondent is also present at today's hearing. Based on the testimony and the evidence, I do find property remains in violation as cited. I'm going to agree to allow the respondent 30 additional days to comply by getting the permit issued. If that does not occur, though, there will be daily fines of $50 per day until compliance is achieved, so make sure that you get that taken care of.
Yes.
All right, thank you.
Thank you.
Thank you very much.
Thank you. Yep.
Agenda item number 11, case number CE 21100192, case address 615 Claremore Drive.
Good morning.
Good morning.
Whenever you're
Joe
ready.
Valdez, building inspector. I have with me Otilio Batiste.
Atilio Bilal,
Bilal, I'm
plumbing
sorry.
inspector for the city of West Palm Beach.
He was assisting the homeowner. This case came on the previous docket,
Okay.
and we gave him an extension to be able to get his permits taken care of. It's a case about the neighbor behind is trying to put a fence
Oh,
up.
I remember this one.
Okay,
With
and
the,
there's some
easement
encroachment.
and the
Yes.
alleged encroachment into the easement with the pool
Right.
equipment and the neighbor, yes.
Yeah, and he did move the pool equipment, but gas lines are still in the way.
Right.
And there's a safety issue also because part of the fence is down and the neighbor has they both have pools, so.
So I know that I rolled this forward to today. I think I was looking for some additional information on.
Well, we have a survey, but the survey's not gonna show the gas lines. It shows the actual concrete to the pool equipment, which he has moved, but I can show you that survey, but it doesn't, when you do surveys, they only show certain things. They're not gonna show like lines or something that come from the ground
No,
and stuff.
I understand. So where are we from the city's standpoint? on this?
Well, Attilio spoke to him, if he can maybe give you some extra information.
Atilio Bilal, inspector, plumbing inspector for the city of West Palm Beach. I met with the homeowner, this gentleman here, and advised him that the gas line was not installed on his property. In fact, it was installed on the property line of his neighbors, obstructing the fence to be installed. I advised the homeowner that they need to
Now, let me
move
just
the
stop
gas
you real
line.
quick. If I remember correctly, you didn't do this. This was
This
pre-existing?
was, gas line has been there, I believe, for 20 years when the
Right.
pool was initially installed.
Okay, and just go ahead and put your name and address on the record.
My name is Brian Doan. I'm the homeowner at 615 Claremore Drive.
Thank you. Okay,
Yes.
that's what I was remembering. Okay, go ahead.
And I advised the new owner that this particular gas line was not actually installed on his property. It was in fact on the neighbor behind him's property. The homeowner then requested for some information. I gave him several contractors to contact in regards to relocating this line to assist him. The city standpoint is on this, that the gas line needs to be on this particular property, and if it's on the property line, it needs to be moved onto his property, regardless of how it was installed. It was initially permitted for the pool heater. I don't have that existing permit number, but that gas line was permitted. However, it was installed in encroachment on the neighbor's property behind them.
All right, so from the city's point of view, the gas line as it exists was properly permitted, but the as built or as installed, they pushed it over a little too far.
Yes.
So, but there was that permit closed out and?
Yes, it was completed. The permit was finalized.
Okay. Okay, let me come back over. Good morning.
Morning. Again, Brian Doan, I'm the homeowner at 615, and I guess our biggest contention with this issue is this is a civil matter. I don't know why the city is getting involved with the property line dispute. This is a gas line that's been there for 20 years, and if my neighbor has an issue with it, there are civil courts that can deal with that, and he could file an ejectment action, and I could file a boundary by acquiescence or a boundary by agreement or adverse possession or whatever claim to give me the right to maintain the line as is. And so I don't understand why the city is getting involved with a property boundary dispute. I don't see how that relates to the Code Division's public mandate to ensure the health, safety, and welfare of the community.
All right. So thank you very much.
Mr. Magistrate?
Yeah.
While I was meeting with the property owner at the property, I don't know if this particular gas line was the gas line for the proper permit that was issued. I did observe some additional gas work that had been performed on the property that had not been permitted. It has not been yet cited. However, if it was done by a previous owner, it now is the responsibility of the current owner. So the property with that gas line may have been altered after the inspections have been performed, and this gas line that we're in reference to may be in fact the one that was done without a permit for such gas work on the property, other than the pool, unrelated to the pool.
Okay. All right, thank you, Mr. Bilal. Let me get the city attorney's input, because, quite frankly, on this one, the evidence that I have at best is that, well, at worst, from the city's standpoint, is that there's a gas line, it was permitted, it was inspected, and it was approved, even though it was put in the wrong place. And if that's the case, then there is no violation, because what's been cited is failure to secure a permit and get required inspections. There's testimony, at worst, that there was a permit and there were inspections. At best, the testimony is that, well, maybe there was a different gas line, but, that's a supposition. There's I have no direct evidence. I'm having a very hard time. I don't think I have competent, substantial evidence in this case to find a violation based on what I've been presented with. I tend to agree with the respondent that, this seems more like a civil matter at this point. Based on what I've been provided, I am not hearing evidence of a code violation. And this may be one of those times that code enforcement is not the proper remedy for the problem that's out there. I mean, if you have a different view, please share it with me. But that's where my head is at the moment.
May I comment? The stop work order that was issued for the gas lines that were encroachment on the easement. That is, in fact, the item at hand. Whether it had a permit and was inspected and approved, if somebody came a day later and installed additional gas lines that were not on that permit, that did not get inspected, that is unknown. However, this gas line is on the neighbor's property. And that's what the code enforcement officer did cite it for, was for gas lines installed encroachment on the property.
No, I understand the gas line is in the wrong place. I don't think anybody has been in disagreement with that. And even based on everything I've heard, there was never, it was not permitted to be put in the wrong place. It may have been permitted to be put in the right place, but there was testimony that it was inspected and passed back in the day. So, in my view, that the code sections that are being cited for alleged violations are not violations.
Special Magistrate, would you give me a moment to confer with staff?
Pardon?
would you, to answer your question that you directed to me, would you give me a moment to confer with staff? Thank you. Thank you, Special Magistrate. May I go forward? Thank you for the time. May I go forward? Okay. In talking with staff, I think it bears clarification, and this would be the city's position to move forward on this and submit that there is enough evidence to move forward. The prior permit that staff talked about that would have been inspected to close it out and confirm that it had been installed correctly, if installation is the correct term. Subsequent to that, the whole point is that the neighbor, the behind property neighbor, in wanting to do what he needed to do, found the gas lines on his property, and that in and of itself would be evidencing that subsequent work on the gas line or manipulation of the gas line had been done subsequent to that initial permit we're talking about. And that's the basis of what we're here for this morning. So that would be the information and evidence that the city has at this time to indicate that something was done subsequent to the initial permit that indicates there is a current violation.
Your Honor, if I may.
Or, I mean, based on the testimony I got, or it was inspected and approved maybe in error, but nevertheless, I mean, go ahead. Who was gonna?
I was going to say that it's kind of speculative there. We don't have any evidence that anything happened after the fact. And we have permits showing that it was originally approved and it went through the process. So I guess that was just my point.
Okay, thank you very much. Anything else from the city on this one?
While I was at the property, I observed a tankless water heater that had been replaced, which would require a gas permit, electrical permit, and a plumbing permit to be performed. That would lead me to believe that additional work had been done to this property without the proper permits. That would indicate that this line, in fact, had been manipulated at some point in some time in order to accommodate for the 199,000 BTU load for the tankless water heater without the proper permits.
Okay. Yes, sir.
Respectfully, that other unpermitted stuff that he talks about is a completely separate thing. I'm willing to work with the city on that. That relates to my actual house, not the actual pool. It's in a completely separate area of the property, and it's unrelated to the gas line that services my pool.
Okay. All right, so, I mean, I found proper notice last time. Everybody's back today, so there's still proper notice, but, I mean, I appreciate the city's position, but with the evidence that I have, it's a lot of supposition. And, you know, it appears that this may have happened kind of evidence. There's no direct evidence of a code violation. And quite honestly, the record contains evidence that may mitigate to the contrary, that there wasn't a violation of failing to secure a permit and get inspections. I'm not going to find a violation in this case today. Now, if the city gets competent, substantial evidence that establishes, in fact, that a violation occurred, I'll be happy to hear that. But what I've been given at the last hearing and today does not get me there. I've already continued this one time to let everybody kind of regroup, and I don't, in my view, the evidence is not there in this case, so I am going to find no violation, and I'm closing this matter with the finding of no violation.
Thank you, Your Honor.
Thank you. Thank you, guys.
Thank you.
Thank you, Your Honor.
I appreciate that.
Okay, agenda item number 15, case number CE 2201-0230, case address 5021 Ellery Terrace.
Can you repeat that case number, please?
Agenda item number 15, case number CE 2201-0230, case address 5021 Ellery Terrace.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. The property at 5021 Ellery Terrace was cited for repeat violation. Original order issued 9/1/21 and trash can violation. The property, as well as City Hall, was posted January 19th. Certified mail was sent January 19th. The repeat violation was observed January 11th. The property was out of compliance for 10 days. With that being said, city's recommending $50 a day for 10 days with a one-time fine of $500.
Thank you, Mr. McFarland. Yes, sir, if you could tell me your name and address, then you can tell me about the case.
Yeah, Roderick Dort, 5021, Ellery Terrace, West Palm Beach. I've been working out of state, and I understand what the inspector is saying. It was for my son to take the garbage inside. But now I'm back working in town right now. I'm in the state, and I'm gonna make sure that the garbage is inside the garage. And since I've been home permanently now, I've been doing that, make sure it's done. And actually, I'm here to ask mercy to the inspector and the board, if you can waive that fee. And that's about it.
All right, thank you very much. Anything else from the city?
In context, I've made 4 attempts to get the property owner to follow the city ordinances. I did it verbally. I did it with notice, and nothing seems to be taking hold here. So with that being said, what the city's recommending is what the city's recommending.
Thank you very much.
Special Magistrate, I'm sorry, I missed the gentleman's name and whether he was the owner or a tenant?
My wife couldn't be here with me because she is sick this morning.
And your wife's name is Susie?
Susie,
Cruz?
yeah, Susie.
Okay, very good.
Yes.
Thank you, sir. Mhm.
All right, thank you very much. So, City has proper notice in this case. The respondent is present. Based on the testimony and evidence, I do find the property violated City Code Section 7434A1J. I find, based on the testimony, that that violation was a repeat violation based on the September 1st, 2021 case where a finding of fact was issued. I find that this repeat violation existed for 10 days. And, you know, sir, while this is not the most serious violation in the world, I am going to accept the city's recommendation based on Mr. McFarland's testimony that he's tried multiple times to get the message across. So I am going to impose the $50 a day for 10 days at $500. And based on what you told me, I hope that you make your son pay you for that, because if you've been away and you've told him what to do and he hasn't done it, then you know, I hope that this can become a lesson in what happens when you don't follow even simplest rules. So I will sign that order, and I thank you for
Mr. Magistrate, there's no way you can at least half of that? It's kind of hard right now.
I understand, but, you know, I'm not going to, and quite frankly, when the city has to do what Mr. McFarland has done and get zero results, I mean, then this is what happens. So I understand it. It's, you know, $500 is a big fine for not putting your garbage can away, but put the garbage can away and be in compliance with city code. That's all it takes. So thank you very much.
Agenda item number 17, case number CE 2112-0316, 430 North Ware Drive. Ms. Montek, is she here? We did have somebody signed in for this. Oddly? Oddly? That's Allison. We have somebody signed up for this case? I guess they left?
They might have left.
Oddly Montek?
We can call that case that she's here for.
Okay. Okay, so
So 20?
yes, sorry. Agenda item number 20, case number CE 2201-0072, case address 420 Lilac Court. And Special Magistrate, I believe the respondent needs to be sworn in.
Say that again?
I believe the respondent needs to be sworn in.
Oh, okay. Go ahead and raise your right hand, ma'am. Do you swear or affirm under penalties of perjury that your testimony in this matter will be the truth, the whole truth, and nothing but the truth?
Correct, right.
And get the microphone a little closer so I can hear you better.
Yes.
Okay, and then go ahead and tell me your name and address while you're...
Okay. My name is Alison Jimenez. The address is 420 Lilac Court.
All right, thank you, ma'am. I'm going to hear from Mr. Cartwright. He's going to tell me about the case, and then when he's finished, I'm going to come back and give you a chance to talk to me as well, okay?
It's fine, thank
Thank you. Go ahead,
Morning.
sir.
Officer Phil Cartwright, City of West Palm Beach Code Enforcement. The property at 420 Lilac Court was originally cited on January 6 of 2021 for repair of interior walls and floors, repair of external windows and doors, repair of roof and foundation, clean and sanitary conditions, excessive overgrowth, exterminating of pests, and electrical outlet repair. Service was achieved by certified mail. The property was posted on January 7th of 2021, as well as City Hall. I have had some contact with the owners of the property. I went by yesterday to do my final inspection, and they are there doing repairs currently.
Okay.
So the city's position is we're asking that the property come into compliance with an additional 30 days or $150 per day thereafter.
100?
Yes.
Thank you. Does any of this work require permits? And if so, have they gotten
That's the
permits?
next case that they have, which is 21. I mean, we could do both. It's just basically they need a permit for
Oh, I see.
the installation of the new air handler and hot water heater.
Let's go ahead and call that case, and let me I think it makes sense for me to hear
Okay.
both of them together.
Also, agenda item number 21, case number CE 2201-0114. Again, case address 420 Lilac Court.
So they have, like I said yesterday, done a lot of repairs inside of the home as far as the floors are concerned, the walls, the overgrowth on the outside. I'd rather do my final inspection for everything with the additional 30 days. That way we can just comply at all.
Okay.
And the only thing that they need to do, I did speak with Ms. Jimenez about the permit that they need to apply for the air handler and hot water heater. We're giving them 30 days to do that as well.
So the only work that needs a permit is the AC system and the water heater?
Yes, sir, that is correct.
Wood rot and
That's just replacing fascia
that's
boards
just-
and stuff on the
that doesn't-
outside.
Okay, and they've already started that work?
Yes, sir, they have.
So they need 30 days to get the permit for the AC and the water heater?
Yes, sir.
And then you're going to wrap it all up
Correct.
with one?
That is correct.
All right, that makes sense to me. Yes, ma'am, go ahead and, are you the resident, are you the tenant of the property?
No, I'm the representative of landlord.
Okay, go ahead.
No, everything we try to fixing. We already fixing a lot of things of the house. We already talked with the tenant. She's agree. We're still working today and maybe 1 week more. We already talked with the inspector. We agree with everything.
Okay, and the city's recommendation of 30 days you're in agreement with?
Yes.
Yes,
Let me get clarification, Mr. Cartwright, are you recommending $100 per day on the case ending in 7/2 and then a separate $100 a day on the case ending in 1/14?
that is correct, sir.
Okay, and that would be my understanding
Yes,
of what
sir.
I would do. I just wanted to make
Yes,
sure.
sir.
Okay, in this case, I do find proper notice. The city has the proper documents in the file. Respondent's representative is present. Based on the testimony and the evidence, I find the property remains in violation as cited in both case 22-01-0072 and 22-01-0114. In both cases, I will allow 30 additional days for the respondent to come into compliance. After that, daily fines of $100 per day for each of the separate cases would be assessed until compliance is achieved. So just so it's clear, worst case scenario, there would be $200 a day running based on the two separate cases. So
All right.
you want to make sure you get that done.
Okay.
Okay? All right, thank
Thank
you
you,
very
sir.
much.
Yes, thank you.
Confirming we have no other respondents present. Okay. Agenda item number 1, case number CE 21070372, case address 342 Puritan Road House complied. Agenda item number 2, case number CE 21120228, case address 619 35th Street is rescheduled. Agenda item number 3, case number CE 22010065, case address 828 35th Street has complied. Agenda item number 6, case number case number CE 22010193, case address 550 South Rosemary Avenue.
Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 550 South Rosemary Avenue was initially cited on 1/12/22. Certified mail was sent on 1/24/22. We do have a signed certified mail receipt on file. The property as well as City Hall was posted on 1/22/22. The notice of violation, notice of hearing was posted at the modular structure located at 550 South Rosemary Avenue, and the property management office located at 700 South Rosemary Street 200. The property was cited for the following code sections: 22-32-A, no certificate of use, 78-430, notice required. They do have a structure there across the public right-of-way with no approvals. 78-431, obstruction of the public right-of-way. 82-144, no business tax receipt, which they need to obtain. And also Florida Building Code Section 102.2, E, which basically deals with a modular structure that does not meet building codes as it relates to the electrical approvals. I met with Phil Petty, who's the chief electrical inspector. I met with him there at the location, and Phil actually provided the code section for the Florida Building Code as it relates to the structure not having approved electrical. I spoke to the property manager, Mr. Stephen Travers. He's the district manager for Related on 12822 regarding this matter. Stephen agreed to having this matter completely resolved by 2/28/22, which would either entail removal of the unit or obtaining the necessary permits and all approvals at a location that may or may not be approved by planning and zoning. If not achieved by 2/28/22, the city is requesting a daily fine of $250 per day until compliance is achieved. I sent Stephen an email just kind of detailing the agreement that this would all be resolved by 2/28, either by approvals from the city or having the unit removed altogether. So that's where we stand with that.
So they just parked this thing and?
Yeah, they just kind of popped it right, I guess, in a to their mind, in a convenient spot across the public right of way.
So February 28th to either move it or get it approved,
Right.
or $250 a day.
Exactly. So I did put them in contact with planning and zoning. They have an individual who they are working with to try and work through the permitting process. We don't know whether it's going to be approved or they might be given an alternative site where they might be able to place it, but that's yet to be determined.
All right. Well, with the signed certified mail, you have proper notice, even though the respondent is not present. Based on the testimony and the evidence, property remains in violation as cited. I will accept the recommendation, allow until February 28th of 2022 for the respondent to come into compliance either by getting the mobile structure permitted and approved in a proper location or by having it removed. If compliance is not achieved within
26 days.
February 28th, there will be daily fines of $250 a day until compliance is achieved.
Thank you.
Agenda item number 8, case number CE 21100-442, case address 6001 South Dixie Highway.
Good morning.
Morning.
Joseph Oliva, Code Enforcement Officer for the City of West Palm Beach. This property was cited on 10/29/2021. Service was accomplished by certified mail sent on 1/10/2022. In addition, both the property and City Hall were posted on 1/10/22. I have been in contact with the owner of the property. The property was cited for 82-144 business tax and 22-32-A certificate of use. As of this morning, the property has not come into compliance. Therefore, the city's asking for an additional 30 days for them to come into compliance. If they did not come into compliance, the city's asking for $100 per day until compliance is achieved. Now, I did go to the property. It's a business that they have over there, and at first, the date I first cited them was 10/29. I gave them a courtesy notice just to get their license. I even spoke with the owner of the business, and to this day, they still haven't done it. So.
Okay. All right, well, city has proper notice with the certified mail and a posting, even though the respondent is not present. Based on the testimony and the evidence, I do find property remains in violation as cited. I will allow the respondent 30 additional days to comply. After that, daily fines of $100 per day until compliance is achieved.
Agenda item number 9, case number CE 22010075, case address 212 Gregory Place.
Joseph Oliva, Code Enforcement Officer for the City of West Palm Beach. This property was cited on 1/6/2022. service was accomplished by certified mail sent on 1/7/2022. In addition, both the property and City Hall were posted on 1/6/2022. I have not been in contact with the owner of the property. The property was cited for 18-106-B, exterior overgrowth, 18-214-B, unsecure vacant structure, 18-215-B, failure to comply, 94-304-E-2-1-B, unsecured fence, 94-445-4-I, prohibited trees on the property. As of this morning, the property has not come into compliance. Therefore, the city is asking for an additional 5 days for them to come into compliance. If they do not come into compliance, the city is asking to abate the property so we could achieve compliance. Now, there's a few different abatements. There's a vacant, the structure is open on one side of the house. There's an unsecured fence that has a pool there that I'm just going to ask our contractor if they could just secure the fence somehow where it's not off the hinges there. And then they have prohibited the pepper, what do you call those?
Brazilian pepper.
Brazilian pepper trees, yeah, in the backyard. And just to clean up the backyard, it's really bad back there.
All right. All right, the city has proper notice with the certified mail and the posting, even though a respondent is not present. Based on the testimony and the evidence, I do find the property remains in violation as cited. I find that those violations constitute a threat to the public health, safety, and welfare. The excessive overgrowth, the invasive species, clearly the unsecured pool and structure, those are all threats to the public health, safety, and welfare in my view. I will accept the city's recommendation. I'll allow 5 days for the respondent to comply. After that, the city is authorized to enter the property, abate the violations, and assess the costs.
Thank you.
Agenda item number 12, case number CE2112022, case address 4501 South Flackwood Drive has complied. Agenda item number 13, case number CE211202271, case address 3114 45th Street, Unit 2.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On December 21st, the property at 3114 45th Street, Unit 2, was cited for business tax receipt and certificate of use. Notice was hand-delivered to the property manager as well as the tenant on December 22nd and also posted at City Hall. Certified mail was sent December 22nd. Certified mail was received December 24th. I have been in constant communication with the property manager trying to facilitate to get this into compliance. I did have a conversation with her on Monday. As of Tuesday, city has received the applications for 2 businesses that were operating without a business tax receipt. They're still in need of fees being paid and inspections. With that being said, city's recommending 30 days to come into compliance or a one-time fine of $250 for the certificate of use. For the business tax receipt, and 30 days or $100 a day on the COU.
All right, well, the respondent is not present, but you got the trifecta of notice with hand delivery, posting, and received certified mail. So you definitely have proper notice. Based on the testimony and the evidence, I will find the property remains in violation as cited. I will accept the city's recommendation and impose one-time $250 fines for the violation of 82-144. Allow 30 days to comply with 2232A. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Agenda item number 14, case number CE211200319, case address 9847 Okeechobee Boulevard.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. on December 28th. The property at 9847 Okeechobee Boulevard was cited for prohibited portable signage. The notice was hand-delivered at the property to the business manager. It was also posted at City Hall on January 13th. Certified mail was sent December 30th. Certified mail was returned January 15th. The property subsequently came to compliance on January 27th. So city is recommending a finding of fact on this particular violation.
What date did the notice of violation require compliance by?
I believe it was, I would have to,
January 13th, and they didn't comply till January 27th. Okay. I will find proper notice with the hand delivery and also with the posting following the returned certified mail. Find the property was in violation as cited, but came into compliance on January 27th, but that compliance was later than the January 13th deadline provided in the notice of violation, so there is a finding of fact entered for this case.
thank you.
Agenda item number 16, case number CE211200300, case address 1667 44th Street.
Officer Williams, City of West Palm Beach Code Enforcement. This property was originally cited on December 23rd, 2021. Certified was sent out December 28th, 2021. That was received December 31st, 2021. The property as well as City Hall was posted on January 6th, 2022. I've had no contact with the owner. I have spoke with the tenant, the owner's daughter. They were originally cited for 2232A, certificate of use required 94-42-A for the vehicles that's parked in the grass of the property, 18162A rental license violation, and 9471-C for the outdoor storage under the carport. As of this morning, 94482 has been complied. However, all of the violations are still present at the address. I spoke to the tenant, the daughter. She did identify herself as the tenant, but then said that her father isn't charging her rent. I did explain to her that he would either need to get a rental license or come into the city and fill out a affidavit of non-rental, which they have not done as of yet.
Neither? Okay. What's the recommendation in this case?
City is requesting 30 days or $100 a day fine
Thank you.
thereafter.
All right, with the received certified mail, the city has proper notice, even though the respondent is not present. Based on the testimony and the evidence, I'll find the property remains in violation as cited, except for 94-482A, which is complied. I will accept the city's recommendation, allow the respondent 30 additional days to cure the outstanding violations. After that, daily fines of $100 per day are assessed until compliance is achieved.
My mic wouldn't turn on. Agenda item number 17, case number CE211200316, case address 430 North Ware Drive.
Officer Williams, City of West Palm Beach Code Enforcement. This property was cited on December 28th, 2021. Certified mail was sent out December 30th, 2021. That was returned on January 3rd, 2022. I have had contact with the owner who did tell me he works out of state and he's working to get these violations cleared. He was cited for 34102A, the abandoned vehicles that are currently at his property. I believe there are two of them. 7434A1J, the garbage can being in plain view
of the public, and 9471-C for the outdoor storage that is present on the property. As of this morning, all violations are currently still there. City is requesting 30 days to bring the property in compliance or a $100 a day fine thereafter.
Was the property in City Hall posted as well?
Yes, I'm sorry. Property in City Hall was posted on January 6, 2022.
Okay, then the city has proper notice with the posting following the returned certified mail. Based on the testimony and the evidence, I find property remains in violation as cited. I will accept the city's recommendation, require or allow the respondent 30 additional days to comply. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Agenda item number 18, case number CE 21120318, case address 218 Gale Place.
Officer Williams, City of West Palm Beach Code Enforcement. This property was cited on December 29th, 2021. Certified mail was sent out December 30th, 2021. That was returned on January 3rd, 2022. I've had contact with the owner, and the property as well as City Hall was posted on January 6th, 2022. They were originally cited for 7434A1J for their garbage can being in plain view of the public. 94442C-1 for sod needed in the front yard where they're parking the cars on the grass, and 9442A for parking vehicles on the grass. After speaking with the owner, he is willing to comply all violations. Him and his wife in there, I think they have like 5 kids that live, adult kids that live with them. That's why they have so many vehicles there. He wants to pull a permit to extend the driveway, pave everything. So he needs he said about 90 days to do that because he's a truck driver. So the city is requesting 90 days to bring the property into compliance or a $100 a day fine thereafter.
Okay, thank you. With the posting following the returned certified mail, the city has proper notice, even though the respondent is not present. Based on the evidence and the testimony, I find the property remains in violation as cited. I will allow the respondent 90 additional days to comply. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Thank you, sir.
Agenda item number 19, case number CE 22010040, case address 737 19th Street.
Officer Phil Cartwright, City of West Palm Beach Code Enforcement. The property at 737 19th Street was originally cited on January 4th of 2022 for landscape maintenance, clean and sanitary conditions, excessive overgrowth, failure to comply, and hurricane hazard. Service was achieved by certified mail. The property was posted on January 5th of 2022 as well as City Hall. The violations that actually have been corrected are 18106-A and 18106-B. All other violations are still current. There's been no contact with the owner. The city is asking that the property come into compliance with an additional 30 days or $100 per day thereafter.
All right, with the posting and the return and the certified mail, the city has proper notice, even though the respondent is not present. Based on the testimony and the evidence, I will find the property has complied with City Code 18106A and B, but remains in violation of the other code sections that were cited in the notice. I will allow 30 additional days for compliance. After that, daily fines of $100 per day until compliance is achieved.
Agenda item number 22, case number CE 22010115, case address 1865 North Tamron Ave.
Officer Phil Cartwright, City of West Palm Beach Code Enforcement. Property at 1865 North Tamron Avenue was originally cited on January 7th of 2022 for clean and sanitary conditions, excessive overgrowth, abandoned junk vehicle, and parking requirements. Service was achieved by certified mail. All violations are still current. I have had conversations with the owner of the property that is asking for an additional 30 days due to him having back surgery. He's assured me that he will come out and take care of everything that needs to be done. I did explain to him that if that is not done, there will be a $150 a day fine running on the property.
Okay.
Phil, was the property in City Hall posted?
The property was not posted, basically due to the nature of the area. It is an area where there are a lot of vagrants and drug dealings that happened on there. So the two sergeants that we work for advised me to basically just go with the certified mail as proper posting.
But you got the certified mail received?
Yes, sir.
Okay. I will find proper notice with the signed for certified mail in this case. Based on the testimony and the evidence, I find property remains in violation as cited. I'll accept the city's recommendation and allow an additional 30 days to comply. After that, daily fines of $150 per day until compliance is achieved.
Thank you, sir.
So,
Agenda item number 23, case number CE 2111018, case address 3605 Eastview Avenue.
Good morning, Natalie Clark, City of West Palm Beach Code Compliance. 3605 Eastview Avenue was cited on November 22nd of 2021. The property and City Hall were posted on December 1st of 2021, and certified mail was sent on November 23rd of 2021. The property was cited for exterior paint, clean and sanitary, and outdoor storage. I've had no contact with the property owner for code sections 18106A and 9471C. The city is asking for an additional 15 days or $100 per day. For 18103J, the city is asking for an additional 60 days or $100 per day until compliance is achieved.
okay. The city has proper notice with certified mail on the posting, even though the respondent is not present. Based on the testimony and the evidence, I find the property remains in violation as cited. We'll accept the recommendation for bifurcated order in this case for 18103J. This respondent has 60 days to comply. After that, daily fines of $100 per day will be assessed until compliance is achieved. For 18106A and 9471C, the respondent has 15 days to comply. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Agenda item number 24, case number CE 2111019, case address 849 30th Street.
Natalie Clark, City of West Palm Beach Code Compliance, 849 30th Street was cited on November 22nd of 2021. The property and City Hall were posted on December 1st of 2021, and certified mail was sent on November 23rd of 2021. The property was cited for 18103B, which is the exterior wall repair, 18103J, exterior paint, trash can placement, and landscape maintenance. I've had contact with the property owner. All violations remain for code section 7434A1H. The city is asking for an additional 10 days or $50 per day. For all other code sections, the city is asking for an additional 120 days or $100 per day until compliance is achieved.
All right, I do find proper notice in this case. I do find the property remains in violation as cited. I will allow 10 additional days to comply with 7434A1H, or daily fines of $50 per day will be assessed until compliance is achieved for that violation. I will allow 120 days for compliance with the violations of 18103B and J, as well as the violation of 94442C1. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Agenda item number 25, case number CE 2112023, case address 3718 Greenwood Avenue.
Natalie Clark, City of West Palm Beach Code Compliance, 3718 Greenwood Avenue was cited on December 20th of 2021. Certified mail was sent on December 21st of 2021, and the property was posted on January 4th of 2022. The property was cited for clean and sanitary, exterior wall repair, exterior paint, landscape maintenance, boarding certificate, land sodding of the landscaping, and outdoor storage. I've had no contact with the property owner. For code sections 18106A, 18265, and 9471C, the city is asking for an additional 15 days or $100 per day. For code sections 94442E, 18106K, 18103J, and 18103B, the city is asking for an additional 60 days or $150 per day until compliance is achieved.
Okay, what was, so for the 15-day, it was 18106A, and what was the other one?
18265 and 9471C.
265 and 9471C.
Correct.
Okay, so with the posting and the signed certified mail, the city has proper notice. Based on the testimony and the evidence, I will find the property remains in violation as cited. For the violations of 18106A, 18265, and 9471C, the respondent is granted 15 additional days to comply. After that, daily fines of $100 per day will be assessed until compliance is achieved. For all other violations, the respondent is granted 60 additional days to comply. After that, the daily fines of $150 per day will be assessed until compliance is achieved.
Agenda item number 26, case number CE 22010152, case address 4011 36 Court.
Natalie Clark, City of West Palm Beach Code Compliance. 4011 36 Court was cited on January 11th of 2022. The property and City Hall were posted on January 12th of 2022, and certified mail was sent on January 12th of 2022. The property was cited for 18107I and 34102A. I've had contact with the property manager. The city is asking for an additional 10 days or $100 per day until compliance is achieved.
All right, thank you. I do find proper notice in this case based on the testimony and the evidence. I do find the property remains in violation as cited. I will accept the city's recommendation, allow 10 additional days to comply. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Agenda item number 27, case number CE 21110104, case address 626 57th Street.
City of West Beach Code Compliance, Robert Watkins. This property was cited on November the 5th. Certified mail was sent November the 8th. Certified mail was received November the 12th. This property was cited for 105.1, 18-106B, 18-162A, 22-32A, 74-34A-1J, 78-94-0, and 82-144 and 94-71C. I haven't had no correspondence with the property owner. I see they applied for the rental permit, but I haven't had any communication to do an inspection. The city is requesting 20 days or $150 per day.
20 or 150?
Yes, sir.
Okay. So rental license was applied for, but it hasn't been approved or issued?
Yeah, it hasn't been inspected yet, so it wouldn't go into the
Okay.
process.
Okay, with the received certified mail, the city has proper notice. Based on the testimony and the evidence, I will find the property remains in violation as cited. I will accept the city's recommendation, allow 20 additional days to comply. After that, daily fines of $150 per day will be assessed until compliance is achieved.
Agenda item number 28, case number CE 21110130, case address 615 49th Street.
City of West Palm Beach, Robert Watkins. This property was cited on November the 8th. Certified mail was sent November the 9th. Certified mail was returned. City Hall was posted January the 10th. This property was cited for 18-106A, 74-34A-1J, 74-35A, and 94-71C. Compliant violations are 74-35A. Remaining violations are 18-106A, 74-34A-1J, and 94-71C. The city is requesting 25 days or at $50 per day after.
50?
50, yes.
Thank you.
Robert, was the property posted?
City Hall was posted. The property was posted as well.
Thank you.
All right, thank you. I do find proper notice with the posting following the return certified mail, even though the respondent is not present. Based on the testimony and the evidence, I will find the property remains in violation as cited, except property has complied with City Code 7435A. For the remaining violations, I will allow the respondent 25 additional days to comply. After that, daily fines of $50 per day will be assessed until compliance is achieved.
Agenda item number 29, case number CE 21110131, case address 641 58th Street.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited November the 8th. Certified mail was sent November the 9th. Certified mail was returned. City Hall was posted January the 10th. This property was cited for 94-482A, 18-106B, 74-34A-1J, and 94-71C. Compliant violations are 94-42A and 18-106B. Remaining violations are 94-71C and 74-34A-1J. The city is requesting 25 days at $100 per day after.
Robert, was the property posted?
Yes.
All right, so we just have the garbage can and the outdoor storage left to deal with?
Yes, sir.
Thank you. With the posting following the return certified mail, the city has proper notice. Based on the testimony and the evidence, the fine property remains in violation of City Code 7434A1J and 9471C. Find the property has complied with the other code sections cited in the notice. For the remaining violations, I will allow the respondent 25 additional days to comply. After that, daily fines of $100 per day are assessed until compliance is achieved.
Agenda item number 30, case number CE2111-0227, case address 708 49th Street.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited November the 17th. Certified mail was sent November 18th. Certified mail was received November 22nd. This property was cited for 18-106A, 18-106G, 18-106M, 26-35-B, 74-34-A-1J, and 94-42A-A. No violations have come into compliance at this time. All violations have come into compliance at this time. As for the repeat, the city is requesting $50 a day, and it went for a total of 15 days. It was a repeat for violation 94-42A. That was with case CE19070258. That was cited on September the 23rd. And that was cited on July the 12th, and that was affidavit of compliance for September the 23rd.
It was 9442A is the violation that is in repeat?
Yes, sir.
Okay.
Robert, can you please testify as to posting the property and City Hall?
Yes, ma'am.
It was
Yeah,
posted?
Well, I didn't post City Hall because the certified mail was received, and I spoke with the owner, but I did post the property as well on November 17th.
And certified mail was signed for in this case, right?
Yes.
Yeah, so you
It
have
was
good
signed and
notice
received.
with the certified mail, even though the respondent is not present. And nothing came into compliance with this, right? Everything's outstanding.
Everything did come into compliance.
everything
but
came into
yes, but
compliance.
as for the repeat, I was giving you the days of the repeat. and
Okay,
it
I understand.
went for a total of 15 days.
All right, so based on the testimony and the evidence, I will find the property has complied with all of the code sections that were cited. However, the violation of 94-482A is a repeat violation based on the 2019 case ending in 258. I will find that repeat violation existed for 15 days, and I will accept the city's recommendation and impose daily fines of $50 per day for those 15 days, which is
Should be $750.
$750 if
Yep.
so ordered.
Agenda item number 31, case number CE2111-0229, case address 704 49th Street.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited on November 17th. Certified mail was sent November 18th. Certified mail was returned. City Hall was posted December the 1st. This property was cited for 18-106A, 18-106M, 26-35-B, 74-34A-1J, 74-4B-1, and 94-71C. No violations are in compliance at this time. As for the repeat, it's in reference to case CE19070251 that was cited on July 12th, 2019, and came into compliance in October for 18-106A, which is clean and sanitary. In this case, the city is requesting for the repeat violations of $25 a day. All violations had to come into compliance and ran for a total of 73 days.
All right, so in this one, everything's in compliance
Yes, sir.
again, and the repeat was in violation for 73 days, you said?
Yes, sir.
Okay,
I've had communication with the homeowner as well, and she's aware of it.
okay. And the property was posted as well as City Hall?
Yes, sir.
And following the return to certified mail, the city has proper notice, even though the respondent is not present. Based on the testimony and the evidence, I will find that all of the code violations that were cited have complied. However, 18106A is a repeat violation based on the 2019 case ending in 251. I will find that that repeat violation ran for a total of 73 days. I'll accept the
1825.
city's recommendation to impose a daily fine of $25 per day for those 73 days. That should be
1825.
73 times 25 is $1,825. So ordered.
Agenda item number 32, case number CE 21120207. Violation address is 621 54th Street.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited on December the 15th. Certified mail was sent December the 16th. Certified mail was received December 22nd. And City Hall was posted January the 10th. This property was cited for 26-35-B, 74-34A-1J, 74-4-B-1, and 94-71C. All violations are still current on the property. I haven't had any correspondence with the homeowner, and the city is requesting $100 per day for the repeat, which is still ongoing, which was stemmed from case CE 201-20233.
Which code section was?
74-4-B-1 and 94-71-C.
Both of those?
Yes, sir.
Robert, was the property posted?
Yes, the property was posted.
What, do they keep putting refrigerators out there to be?
Everything's out there. There's refrigerators, deep freezers, all on the other side. It's like they live outside, it seems like.
Okay. And what's the daily fine that you're asking for?
$100 per day.
When was the repeat violation first observed?
December the 15th.
And for the garbage can placement, that one's not a repeat, or it is?
It was as well.
All three
both
of them
those,
are?
yeah.
Okay.
The 74-4-B-1 is, and the 94-71C, the garbage can placement wasn't.
Okay, so with the certified mail that was received, the city has proper notice. Just so I'm clear, so the garbage can placement, remove appliance doors, and outdoor storage are all repeats?
Yes,
And
now
they're all
they-
still, none of them have been cured?
No, they're all still out there. Now they have
Okay.
outdoor heaters and stuff.
So we'll
out
make
there.
that finding. I find that property remains in violation as cited. I find that the violations are repeat violations based on the case that you put on the record. I will impose daily fines of $100 per day beginning on December 15th and continuing through today and until compliance is achieved.
All right.
Agenda item number 34, case number CE 21100049, case address 1200 North Sapodilla Avenue, Unit 5.
Did you mean to skip 33? I'm just asking.
I was trying to hold my sneeze in, so I skipped. I apologize. Agenda item number 33, case number CE 21090274, case address 1030 South Mangonia Circle.
Good morning, Officer
Morning.
Luster, West Palm Code. Property was cited for exterior painting, clean and sanitary condition, garbage can placement, outdoor storage, repair of rotten wood, and property was, certified mail was received on 9/30/2021. Property was posted on 1/10/2022. I've had no contact with property owner. I'm asking for 60 days or $50 per day after.
All right, I do find proper notice with the received certified mail. Based on the testimony and the evidence, I will find the property remains in violation as cited. I will allow 60 additional days for compliance. After that, daily fines of $50 per day will be assessed until compliance is achieved.
Thank you.
Okay, now number 34, case number CE 21100049, case address 1200 North Sapodilla Avenue, Unit 5.
Officer Luster, West Palm Code. Property was cited for extermination of pests, roof, walls, and foundation repair, ceiling repair, roof repair. Property also was cited for interior wall repair, interior ceiling repair, external doors and windows, exterior painting, and cleaning sanitary conditions. I have had contact with the property owner on 12/22/21, back on 10/20/21, and there's also an email in the case from 1/21/2022. Certified mail was returned to us on 10/15/2021. Posting happened on 1/10/2022. He's asking for 90 more days because he still needs to pull a roof permit, and that's going to take some time, I'm assuming. He's asking for 90 more days.
And daily
Or
fine.
$50 per day.
Pardon me?
Or $50 per
Thanks.
day.
Okay, with the posting following the returned certified mail, the city has proper notice. Based on the testimony and the evidence, property remains in violation as cited. I will allow 90 additional days to comply. After that, $50 per day will be assessed until compliance is achieved.
Thank you.
Agenda item number 35, case number CE 21100091, case address 1356 9th Street.
Officer Luster, West Palm Code. Property was cited for junk and inoperable vehicles, in public view, obstruction of public right-of-way, sidewalk, unpaved parking, outdoor storage, failure to obtain a building permit, and cleaning in unsanitary condition. The property was, certified mail was signed on 10/12/2021. Property was posted on 1/10/2022. I have spoke with the property owner at posting, and she's asking for 90 more days or $50 per day. The following violations that are in compliance are the junk and operable vehicles, and that is 34102A and the 34102C. All other violations remain.
What was the failure to secure building permit for?
She had a screen enclosure that she was attempting to actually just go ahead and enclose. And there's a shed in the rear of the property that has no permits. Okay. And the driveway for the unpaved parking, she will need to obtain a permit to comply to approach to the driveway.
But the unpermitted work was the building or the shed and
A
the
shed
screening?
and the screen enclosure that's right there.
Okay,
She attempted to start enclosing it
yeah,
without a building permit.
got it. All right, with the certified mail that was signed for, the city has proper notice. Based on the testimony and evidence, I will find property remains in violation as cited, except for 34102A and C, which have complied. I will allow an additional 90 days to cure the remaining violations. After that, daily fines of $50 per day will be assessed until compliance is achieved.
Thank you.
Agenda item number 36, case number CE 21110127, case address 1311 11th Street.
Officer Luster, West Palm Code. This property was cited for failure to obtain a building permit for fencing, cleaning unsanitary conditions, painting of unit, rental license, certificate of use, garbage, debris, and overgrowth, the tree and hedge obstructing right-of-way, which is the easement, cleaning of easement and or swell to majority of the road, numbering standards, above-ground pool, and trimming of trees and bushes, and unpaved parking. The only violation that has come into compliance is the numbering standards. All other violations remain outstanding. I'm asking for 60 more days or $50 per day. And the property was, certified mail was received on 11/15/2021, and it was posted on 1/13/2022. I'm asking for 60 or $50 per day.
All right, with this received certified mail, the city has proper notice. Based on the testimony and the evidence, I will find the property remains in violation as cited, except for 78-6 of the city code, which has complied. I will allow an additional 60 days for the outstanding violations to be cured. After that, daily fines of $50 per day will be assessed until compliance is achieved.
Thank you.
Agenda item number 37, case number CE 21110-260. Case address is 1332 10th Street.
Officer Luster, West Palm Code. This property was cited for safe egress, roof, rotten wood replacement of soffit and overhang, which is fascia, exterior doors and windows, broken windows, exterior painting of property, clean and sanitary condition, landscape maintenance, junk and operable vehicle, inoperable vehicles out in view of public, garbage can placement, overgrowth, tree and hedge obstruction of right-of-way, clean and unsanitary condition for is easement and right-of-way, obstruction of right-of-way, and numbering standards, fence and wall maintenance, landscaping of property and landscaping of swale and outdoor storage. Violations that are in compliance are the obstruction of the right-of-way, which is 74-4C4, and obstruction of right-of-way, 78-1. All other violations remain outstanding. I have spoke with the property owner, with the persons that reside, which is a grandson that resides at the grandmother's home. I have spoke with the property owner's daughter. They've informed me of the condition of their mother, which is 97 years old, and she's going through a lot of medical issues. So the daughter has relocated here from Texas, and she's asking for 6 more months or $50 per day to bring all violations into full compliance. And property certified mail was received on 11/20/2021, and posting was on 1/10/2022.
Okay, with the received certified mail, the city has proper notice. Based on the testimony and the evidence, I will find property remains in violation as cited, except for City Code Sections 74-4C4 and 78-1, which have complied. Based on the testimony and the circumstances in this case, I will agree to grant the 6-month, 180 days, I guess, 6 months,
Yep.
to cure the violations. After that, daily fines of $50 per day will be assessed until compliance
Thank
is
you.
achieved.
Agenda item number 38, case number CE 2112-0041. Case address is 1528 6th Street.
Officer Luster, West Palm Code. This property was cited for clean and unsanitary conditions, junk and operable vehicle, parking on public right-of-way as prohibited vehicle, parking prohibited vehicle on public right-of-way, unpaved parking, and prohibited vehicle. All violations except for clean and unsanitary conditions, which consist of cleaning of driveway and sidewalk. All other violations are in full compliance. I'm asking for 15 more days or $50 per day. I have spoke with the property owner. I met them at the property. Told them what the violation consists of, told them what they needed to do to come into compliance. And I met them on 1/14/2022, and it's still out of compliance. So I'm asking for the 15 days or $50 per day
And
after.
it's just the clean and sanitary
Yes,
at this
sir.
point, all right. Oh, what was,
Oh, certified mail was returned to us on 12/11/2021. Posting was on 1/13/2022.
okay, and that was on site and at City Hall?
Yes, sir.
Thank you. Then with the posting following the return certified mail, the city has proper notice even though the respondent is not present. Based on the testimony and the evidence, I will find the property has complied with all code violations cited in the notice except for City Code 18106A. I'll allow an additional 15 days for that violation to be cured. After that, daily fines of $50 per day will be assessed until compliance is achieved.
Thank you.
Agenda item number 39, case number CE 2201-0044. Case address is 600 South Mangonia Circle.
Officer Luster, West Palm Code. Property was cited for clean and unsanitary conditions, excessive growth, landscape maintenance, overgrowth, tree and hedge obstructing right-of-way, meaning easement, cleaning of easement and to road, fence repair, fence maintenance, and landscape maintenance. This property certified mail was returned to us on 1/8/2022. Property was posted on 1/10/2022. I'm asking for 10 days or abatement.
Was City Hall posted too?
Yes, sir. Yes, ma'am. It was, City Hall was posted on 1/10/2022.
What is the right-of-way obstruction?
Right-of-way obstruction is it's in the rear of the property, and it's between you can see the hedges, and it's a big bush right there. You can see it from the other, that one.
Okay.
And this is a severely overgrown property, so it's real unsafe and hazardous for snakes, rodents.
I see, okay. All right, with the posting following the return of certified mail, the city has proper notice. Based on the testimony and the evidence, I will find the property remains in violation as cited. I will find that those violations constitute a threat to the public health, safety, and welfare. I will allow the respondent 10 additional days to cure the violations. After that, the city is authorized to enter the property, abate the health, safety, welfare violations, and assess those costs.
Thank you. Have a great day.
Okay, thank you. So next agenda, 11:30. All right, let's go off the record. We'll be back in about 9 minutes.